Second Child versus Edge Auto. Counsel?
Good morning, and may it please the court. Walter Santiago Jr. of DAC Beechcroft LLP on behalf of appellants. I'd like to reserve 3 minutes for rebuttal.
Yes.
Thank you. The certified question put before this court from the First Department is whether the First Department's decision upholding the lower court's decision was properly made. The issue is whether the primary coverage under Vehicle and Traffic Law 370 as it applies to rental car agencies doing business in the state of New York is preempted by the Graves Amendment. Now, primacy of coverage under Vehicle and Traffic Law 370 is not a new issue for this court. In fact, it's a decided issue that was decided in the case of LRAC v. Ward in 2001, where this court held that the language of Vehicle and Traffic Law 370 is plain and precise. It requires car rental agencies such as Respondent Edge Auto to obtain the mandatory minimum amounts of insurance, and those minimums shall inure to the benefit of every permissive user of a motor vehicle.
But why isn't that preempted? Really, that's the question, right? And LRAC is before the Graves Amendment. So why isn't that statute preempted by Graves?
Sure, and it's not preempted by the Graves because the Graves Amendment includes a financial responsibility savings clause that carves out financial responsibility laws of the state of New York. And under that financial responsibility savings clause, Vehicle and Traffic Law 370 is saved because it's not a vicarious liability statute.
What is it?
It's compulsory insurance coverage
To cover liability.
to cover the renter or the renter when they are renting the vehicle, not to cover liability.
How is that substantively different than liability?
Well, vicarious liability is being held vicariously liable
Makes
for the
sense.
acts of another, whereas compulsory insurance coverage is coverage that must be obtained and provided, so then that
So if
way
they
innocent
said
victims
you
have.
cannot be held vicariously liable, and no state law can do that, and then the state puts in a law that says you're not vicariously liable, but you're liable.
Well, not that you're liable, because effectively the renter becomes an insured underneath the rental company's insurance policy. And because they're an insured under that policy, then those minimums kick in.
But it seems to me, that, and maybe I'm reading it wrong, that the New York legislation is not that. It does not say they become an insured. It says you have to have this insurance. And my understanding, at least, and I'll ask the AG this, is there's some type of penalty for not having that insurance that somehow transfers into you're liable for defending an action and up to the minimum standards of the insurance, which kind of sounds a lot like vicarious liability to me.
What the statute says, Your Honor, is that those minimums shall inure to the benefit of every permissive user. And in LREC v. Ward, that was determined to be primacy of coverage. And understanding that 2001 was LREC v. Ward, and then in 2005 we had the Graves Amendment,
Well, was
still
LRAC,
does not
was
preempt
LRAC,
Vehicle and Traffic Law
was
370.
LRAC deciding primacy and non-contributory status under both 388 and 370 or just 370?
Your Honor, although it discusses an interplay between 388 and 370, there's no analysis of 388 in the LREC v. Ward case. It's all pertaining to 370 and what's required of
Do
370.
you concede that 388 is preempted?
Correct, Your Honor.
Okay, so what about this argument, and it's touched on in LRAC, as you say, that the two provisions, 370 and 388, are completely intertwined? Shouldn't one fall if the other does?
Well, they're not completely intertwined. What the court said was it was discussing an interplay, but there was no analysis about an interplay between 388 and 370 in Ward. In fact, in one of the opening lines of Ward, the court automatically says that they were found liable under 388, and then it goes into do an analysis on what's required under 370, and that's that the rental company has to have the minimums and that they shall inure to the benefit of every permissive user. The savings clause underneath the Graves Amendment was not by mistake. That was by design, and that's because of the McCarran-Ferguson Act, which states that
Do you think there is interplay or there is not?
at one point there was an interplay between them.
And the reason there's not now is that 388 is preempted?
Well, 388 was preempted, but 370 was left intact. The legislator could have changed 370 when it enacted the Graves Amendment, but it did not.
But isn't it really our interpretation of 370 via Ward that now is not really relevant anymore after Graves?
Well, no, 370 is still relevant because
No, but you're relying on our interpretation of 370 via Ward.
well, the starting place for any statutory interpretation is the language of the statute itself. And 370 could not be any clearer. It says that those minimums shall inure to the benefit of every permissive user. The word shall is a word of command. There's no discretion there. It compels compliance with the statute that those minimums shall inure to the benefit of every permissive
Counsel,
user.
where's the faulty reasoning in the view that 370 exists in service of 388? 388 creates the liability and 370 creates the financial obligation that guarantees that that liability is going to be covered financially. So if you don't have 388 anymore, then you don't really need those provisions of 370. And that's the, I don't know if you want to call it intertwining or interdependence, but if one leg of the stool goes, you really don't need the other one. Although a two-legged stool would be a very bad thing to have.
Well, again, 388 was preempted by the Graves Amendment. What it did not preempt was 370.
No, but my question is, why do you even need 370 if there's no 388? And that sort of leads you to thinking maybe it really was part of what the amendment was trying to get to.
Well, because again, we're comparing vicarious liability to compulsory insurance coverage. That's apples and oranges. Vicarious liability would be the rental company being held liable for the acts of the renter, which in this case, they're not. What we're saying is that under VTL 370, the renter isn't insured underneath the rental company's insurance policy and by the rental company to the extent that they're self-insured.
But the over here, I'm sorry. But the insurance company is the one that pays the premiums, and it's their insurance. So yes, the through line is going all the way to the insurance company. Why isn't that effectively, right? It's not. Yes, I think you're right. It's not obviously vicarious liability, but it's effectively the same.
Well, I would argue that it's not because under New York Insurance Law 3420, every single motor vehicle insurance policy written in the state of New York has to insure the permissive user of that vehicle. And that is why the renter becomes an insured underneath Maya, in this case, insurance policy, and to the extent that...
Does the fact that you're insured equal liability?
No, it does not equal liability, but we also have a slew of statutes in the state where there's no liability, such as no fault, underinsured, uninsured. This is compulsory insurance coverage, so that way innocent victims of traffic accidents have means to critical insurance
Can you respond to what I take to be a conflict preemption argument, which is that the purpose of Graves is to reverse the cost shifting that had taken place, and that allowing 370 to continue to be applied is fundamentally inconsistent with that objective?
Sure. So Vehicle and Traffic Law 388 formally imposed vicarious liability on an owner of a motor vehicle simply by them just being an owner without any evidence of any wrongdoing. That is what Graves' amendment sought to do away with. In fact, Vehicle and Traffic Law 388
Well,
was
that's
the driving
the
force.
question, I think, right? I mean, in the conflict preemption analysis, I think the question is, what did Congress mean to achieve? And I think that your adversary is arguing that there was a broader goal, which is there was an intent to stop the cost shifting that was effectuated by 370 and 388 and similar statutes in other jurisdictions. So why isn't that broader purpose the actual objective?
Sure, and that's because under the former 388, there was limitless liability. The rental companies would be held vicariously liable up to whatever the judgment
I'm not
was,
sure
whatever
that's
those-
responsive, maybe I'm missing it, to the question of what Congress intended, though, with Graves. I take it your view of Graves is that the objective was somewhat modest, which is simply to end vicarious liability, but not more broadly to prohibit the cost shifting that is effectuated by the kind of requirement at play in 370. So what's the support for that in Graves and its legislative history?
Well, sure. The support for that is the enactment of the financial responsibility clause that goes along with the Graves Amendment. The legislature did not have to include that, but they did it by design because they recognized that matters of insurance are left to the states to regulate. And then when it comes to the preemption analysis, you also have the the state that regulates the business of insurance, and then you have the McCarran-Ferguson Act, which states that no act of Congress shall invalidate, impair, or supersede any state law that has been enacted to regulate the business of insurance, which is exactly what we have here. If the Graves Amendment stood for the principle that respondents suggest that it does, then it would preempt the peremptory mandate of Vehicle and Traffic Law 370 that those minimums shall inure to the benefit of every permissive user.
So if I understand your argument correctly, you believe that what Congress was trying to do was to stop sort of what you called limitless vicarious liability, but to allow states to say, to set whatever amount they want of insurance that a company must hold on its own.
Exactly.
That's your argument. That's preserved by the Savings Clause.
Exactly.
Right.
Counsel, so following up on that, if this statute had said, the New York statute 370, had said you are required to have a policy to cover whatever damages, if there were no limits in 370, the same language, but no limits, that would be okay or not okay?
Well, that's what 388 previously did. There was subsection 4 of 388.
But let's say now it's in 370, same language without the policy coverage limits. Okay or not okay?
Well, then at that point, the rental company would not be able to seek indemnification. There would be no limits. But what Congress did was they did impose those limits: 25, 50, 10, 25,000.
My question, if the statute read, without the limits, same language, no policy dollar limits, but 370 language, would that be okay in your view or not okay under Graves?
Well, it would be okay, and the insurance
Well,
would
then
have
why
to
are
respond
you
to that.
arguing it's the limits that make the difference?
Well, because the limits are what's in play. We're going by the exact language of the statute. The statute doesn't say that it's limitless.
But it doesn't matter in your view.
No, it doesn't matter. It doesn't matter if the renter is at fault.
So
then
how
they're
can that be
insured
the
underneath that
distinction
policy.
between what's allowed and what's not allowed under Graves? Because I thought your argument was before that this is different because there are policy limits in there up to certain amounts. But now it seems your answer to this question is it doesn't matter.
Well, again, we're going by the exact language of the statute, and just using that, your hypothetical, if the statute said that those minimums, or whatever the case may be, whatever those amounts were, had to inure to the benefit of every permissive user.
No, I want the exact language the statute has now, but without the dollar limits. Is that good or bad under Graves?
Well, then that would still survive under Graves because of the financial responsibilities
So
carve
it's
out.
not the dollar limits that make it okay.
No, it's not the dollar limits that make it okay because, again, it's the insurance policy for the rental company that comes into play. The renter isn't insured under that policy, even under 3420. So if we're saying that 370 is preempted, we're also saying that 3420 is
Under that theory, then, you just could put 388 into 370, basically, because it could be limitless amount that you are not liable for, but insuring the driver.
Well, there's a difference here because 388 was vicarious liability. This
No, I
is
know, you just
compulsory
rephrase
insurance
it
coverage.
as it's not your liability, you're just paying for someone's coverage for their liability.
Well, Your Honor, let's say that there was a third party at fault and those minimums kicked in, or if it was a limitless policy that kicked in, then the rental company would be able to subrogate, or their insurer would be able to subrogate and go after the at-fault third party to recover the amounts that they had to pay out. That's the difference. This is insurance, not liability, not vicarious liability.
Does it really matter if it's vicarious liability or primary coverage? Why isn't the AD right about that? It doesn't even matter. And why aren't the other states right about that?
Well, absolutely, because, well, number one, the other states, they either address vicarious liability statutes and or their statute did not have the peremptory mandate. It did not have that word shall in there. What the First Department did was they effectively read the word shall out of the statute.
Yeah, but even if they have caps, other states have said it doesn't matter. It's preempted. Graves preempts it.
Again, this is not vicarious liability. This is compulsory insurance coverage under the state of New York. And the state of New York is left with the ordeal to deal with that, right, by virtue of the McCarran-Ferguson Act. And so the state of New York's present here today in their amicus filing demonstrate that they agree with the appellant's position on that issue.
But why doesn't the savings clause just apply to the other types of insurance, property insurance, no-fault insurance? Why do we read it? Why should we read it the way you want to read it?
Because Vehicle and Traffic Law 370 is in fact a financial responsibility statute, and in the dimensional case cited in the briefs, the Second Department also found that it was. Other courts have also found that it falls within that financial responsibility clause, so it's saved. Then the question becomes, is it
Anything could
imposing-
be, you could argue that anything is a financial responsibility clause, and then the exceptions swallow the rule.
Well, in the other case, the Graves Amendment would swallow the peremptory mandate of Vehicle and Traffic Law 370 that those minimums shall inure to the benefit of every permissive user.
I mean, I feel like that argument is a little circular.
I would argue it's not, Your Honor.
What is it you think that the savings clause was intended to preserve?
The Savings Clause was intended to preserve the state's right to regulate the business of insurance at the state level. In this case, we have Vehicle and Traffic Law 370.
Well, it can't be quite that broad because 388 is preempted.
Correct.
So what is the limit on the savings clause?
Well, there is actually no limit written into it, but what we do have is we have limits written into the Vehicle and Traffic Law 370. So the Savings Clause saves financial responsibility laws of the states, and then we have Vehicle Traffic Law 370, which no longer imposes this limitless liability, which is what Graves Amendment was concerned
What
with.
does financial responsibility standards mean? I mean, isn't that a key question? How are we supposed to know how broadly to read that?
Sure. So what it does is it imposes the minimums, again, commonly referred to as 25, 50, and 10.
No, I'm
But
asking
it doesn't
about
stop there, Your Honor.
In the Graves Amendment, how do we know what a financial responsibility law encompasses?
I don't recall whether there is an actual definition or if they go into defining it within the Graves Amendment.
Why should we read it as broadly as you're proposing?
Because it's the pure language of the statute.
Well, I'm not sure sitting here that I know what financial responsibility law means. That's what I'm asking you. What do those words mean to you?
So financial responsibility means, in terms of this instance, that the rental company has to obtain those minimum amounts of insurance. But again, the statute does not stop
But
there.
if we look at the text, it seems to me that it is perhaps something distinct. It's financial responsibility or insurance standards. So that suggests to me that maybe it's something other than insurance.
Well, we actually have both in Vehicle and Traffic Law 370. You have the minimums, and then you have the insurance standard. The renter effectively becomes an insured
No, but why
underneath
doesn't
the
it
policy.
mean what other states have taken it to mean, that it's their own liability and negligence for something that their drivers have done? Like if you're on a lot and one of their agents is moving that car and it hits somebody, then for their negligence, they have to have insurance. Like, why doesn't that make sense?
Well, that makes complete sense that they have to have negligent insurance for their own negligence. But in this case, they also have to have insurance to cover the renter of the vehicle up to just the minimum amounts.
Your interpretation conflicts, just it seems to me, with a fundamental goal of the Graves Amendment. But to read financial responsibility, which I think is more of a natural reading, as whatever your liabilities are, you have to be able to cover them. So I think Judge Singas gave an example, or you lease somebody a car that hasn't been properly maintained, it causes an accident. We, New York State, want to ensure that people can recover who are injured because of your negligence. And that, to me, is financial responsibility. Financial responsibility isn't extending your liability and then making sure you can cover it, which I think, it seems to me, is the purpose of the Graves Amendment, not to extend that liability.
So the driving force behind the Graves Amendment was Vehicle and Traffic Law 388. Its purpose was to do away with limitless liability. Again, when Congress enacted the Graves Amendment, they could have done away with VCL
recently,
370.
I think, that you could impose limitless liability through the 370 mechanism.
That's not what the statute says.
No,
Again,
I know, but under your reading of Graves, I believe you told me that you think it could be limitless liability under 370. And if we decide on that theory, tomorrow the legislature could pass a limitless liability standard under 370.
What the legislator intended, again, Your Honor, was to do away with vicarious liability up to limitless limits. That's not what we have here. It's not vicarious liability. This is insurance coverage. Again, if the rental company is not at fault and there's a third party, they can subrogate to go after those amounts that they were.
Counsel, relative to that point, can I just ask you, under the current state of the law, 370, which includes just the minimum, statutory minimum requirements, Could a renter's carrier, could a rental agency's carrier subrogate its claims to persons liable?
If it was the renter, no, because then that would go against the
No, the
anti-subrogation rule.
rental company's carrier.
Could the rental company's carrier...
The rental company that's required to carry the policies with the statutory minimums, under the law as it exists today, could they seek subrogation?
Correct. If there was an at-fault third party, yes, absolutely. They can seek indemnification for the amounts that they had to pay out.
They still have to defend. They have a duty to defend.
Correct, under Vehicle and Traffic Law 370.
Thank you.
Thank you.
May it please the court, Stephen Yanni for the New York Attorney General. Vehicle and Traffic Law 370 doesn't impose vicarious liability on rental car companies.
Can you address over here? Can you address what you think financial responsibility standards in the amendment encompasses?
It encompasses any minimum insurance requirement, and that's borne out in the legislative history of the Graves Amendment. While the Congress was clearly concerned about limitless liability without fault, but at the same time, even the proponents of the Graves Amendment recognized the problem of limiting the recoveries by accident victims. And
I don't think they were concerned with limiting it. I think they were concerned that car rental companies shouldn't have to deal with the liability of things that their agents and their negligence caused. I think it was very clear that they were saying, and they looked at New York as an example, that they shouldn't be footing the bill unless they were liable. So I don't see where the limiting has come in. I think it's come in through your interpretation of it, but I think that's a little revisionist history.
So clearly the Congress mentioned multiple times the problem of limitless liability without fault. The problem that was creating is that rental car companies were being subjected to huge judgments from statutes like Vehicle and Traffic Law 388. But at the same time, the proponents of the amendment clarified that rental cars on the road would still need to meet the state's minimum insurance requirements. So
They were focused, Congress was thinking about New York, right?
Yes.
And by that point, New York, we decided SNAPY, right, which allowed indemnification by the renter, yes?
Yes, that's correct.
How does that then square with the idea that Congress was worried only about the limitless liability because there were contractual limits on the liability in place in New York?
Well, Congress never mentioned laws analogous to Section 370 in the legislative history. They were only talking about laws that impose this kind of limitless liability, as we were discussing. And I want to make clear that vicarious liability and insurance standards are both ways of mitigating risk, but they're distinct both legally and practically in really important ways. So vicarious liability is imposed ex post based on a duty of care that arises out of a relationship of control, and you're exposed to potentially unlimited liability, whereas insurance standards like Section 370 impose an ex ante duty to obtain insurance that spreads costs among the industry participants, and you're responsible only
Counsel,
for...
do you agree with your co-counsel that they could put a limitless provision in 370? It has limits in it now, but what if they took that out?
If there weren't limits, then it would still fall under the express text of the
Why do you
savings
keep
clause.
talking about limits? It doesn't matter under your theory.
Well, what's critical is where the duty runs. That's what distinguishes vicarious liability from.
But
a
if
duty
we
to
were
insure.
to agree with your argument here on the preemption point, tomorrow the legislature could amend 370 and take the limits out.
But at the same time, Congress could then prohibit states from imposing onerous insurance standards if that was the problem it was trying to address. But it was trying to
You just
address a...
told me they were trying to address limitless liability. But now, under your theory, this legislature could put limitless liability in 370, and then they'd have to go back and say, no, we really meant it.
Well, Congress was taking aim at a very specific problem that was being caused by vicarious liability laws. They could have enacted a law saying that states can't have minimum insurance requirements that have very high limits. They could have done that, but they didn't. Perhaps in that...
Go ahead, sorry.
I was going to say, perhaps in that case, there might be a stronger conflict preemption argument if, like, in fact, you were imposing the same kind of onerous costs that prevent businesses from doing business in the state, but it's not relevant to whether it falls under the express text of the preemption clause, which it doesn't.
When you say the legislative history supports your reading of Graves as allowing statutes like 370, I see some references at pages 3 to 4 of your brief. Is that the extent, a comment from Senator Graves, is that the extent of the legislative history you would point us to?
So those, I think, are the most helpful provisions. On the legislative history at page 4099 and
But what that says is that the rental vehicles have to meet the state's requirements for insurance. How does that go to who bears the cost of that? I mean, it seems maybe self-evident, I don't know, to me that a car on the road is going to have to meet insurance requirements. That doesn't answer who pays for that insurance.
I think one thing that's relevant to that consideration is that, as we've cited, the insurance, one of the insurance treatises in our brief, Couch on Insurance, it's very common for financial responsibility laws to require coverage for.
But how do we know from the legislative history that you're pointing us to that reflects the intent that you're suggesting it does?
Well, I think another comment that was made in legislative history is that, from the sponsor Graves, is that vicarious liability doesn't protect against uninsured drivers. It simply provides higher compensation based solely on the fact that the individual owns the vehicle. So, I mean, they were trying to, they're responding to the arguments about having no recourse for victims by pointing to a state minimum insurance
I think we're
standards, but
trying to
without-
understand what the carve-out, what the savings clause encompasses, right? I think that's the crux of the question. So I just want to make sure this is the extent of the legislative history, because it seems to me perhaps it's not quite as pointed as you suggest it is. Doesn't mean that's not what they meant, but
Well, I would say there's nothing to suggest in legislative history that these minimum standards that were preserved did not include coverage that would extend to the drivers. I would note there was also an effort to repeal the Graves Amendment in 2010, and there was testimony received in relation to that, to the proposed amendment from the industry groups that wanted to preserve the amendment, and they pointed to the fact that these minimum insurance standards were preserved as a reason to keep the Graves Amendment and argue against the need to repeal it.
Is it possible to read the Graves Amendment and the Graves Amendment and the savings provision and the legislative history and conclude that what Congress was trying to do was to preempt the primary nature of insurance held by rental car companies, but not the requirement to insure?
No, I don't think there's a way to read it like that. The respondents here don't explain how 370 doesn't qualify as a financial responsibility or insurance standard under the plain text. In fact, they agree that Section 370 is not preempted as applied to uninsured drivers, and which they call secondary coverage. But in that scenario, the rental car company's insurance is still paying up to the specified minimum limit. So if that's not vicarious liability, then nor is providing primary coverage to an otherwise insured driver.
Counsel, could I ask you about some language in your brief? On page 13 of your brief, it says, Section 370 leaves renters responsible for their own negligence. I understand that position. While rental car companies' liability is limited to the harm resulting from the breach of their duty to provide insurance. What does that mean?
So I'll say if the rental company is complying with the statute, then it has no liability. It's just responsible for covering the insurance premiums. But if the rental car company doesn't obtain the insurance as required by Section 370, then any liability that arises from that is a result of their breach of their statutory obligation to obtain insurance. It's not liability that arises from the driver's
So if they have insurance, they're liable. In theory, they're not liable, but they are responsible, let's say, for paying up to a certain amount and defense costs. But if they don't have insurance as required, they're liable for that same thing?
Well, the liability arises from a different source. It's not vicarious.
But what's the
liability.
dollar amount of that liability, the penalty?
The liability is limited to what the insurance would have provided. So it would be the minimum liability standards and the defense costs. But that's but those damages
even if they did not get coverage, is that what you mean?
Yes, if they fail to abide by Section 370 and didn't obtain the required coverage, then they would be responsible for their own damage that they caused by violating the statute and failing to obtain that insurance.
Which would be up to whatever the insurance would have covered?
Correct.
And is there some formula about what it would have covered? I mean, people get different kinds of insurance packages.
Well, they'd be responsible for the minimum liability standards that are laid out in the statute. So
Okay.
$25,000 for injury.
I see.
et cetera.
Okay, so it would be whatever the statutory minimum is. Okay,
That's exactly right. And
okay.
I also,
But, I understand your, of course, doctrinally, your distinction between the liability and these insurance coverage and the payments, but the point of liability is just to make someone pay, just make it very practical. That's the bottom line. Who is going to pay for whatever damages are established? Liability is a means to figure out who's going to be held accountable for those payments once you establish the causation and the damages. So again, you're still back to the rental company through their insurance company. Let's just assume for one moment they have coverage, they've complied with the statute otherwise, is going to be paying, as has already been noted by several members of the court, for damages, injuries caused by someone else. And that does seem to be right at the heartland of what Graves is trying to address.
well, what they'd be paying for is the damages that they've caused by failing to obtain the insurance. I think that's the critical distinction, where the duty is arising from. They're not being held vicariously liable based on a duty.
No, I don't see that. They are paying for, again, the damages or the injuries that's caused by someone else, not by their own negligence. Let's just take a simple hypothetical. Not by their own actions and negligence, right? By someone else's. We could all agree that that's the hypothetical. The fact of the pool of funds by which they pay that off strikes me as not a very good differentiating line. They're still responsible, as you've conceded, and counsel is going to concede, already conceded, they have to pay for the premiums. So there is some payment that's coming from the insurance company based on these damages or injuries that have been established.
Yes, there's payment from the insurance company.
Yeah.
But there's no, in any event, the rental car company is not being held responsible for the actions of the driver.
But it doesn't appear that Congress cared about the doctrinal argument for why they're responsible. They cared about the fact that you're making these rental companies pay, and that's a burden on their business, maybe putting them out of business, or am I misunderstanding the purpose behind that amendment?
I do disagree with that, Your Honor. I think that through the savings clause, they expressly wanted to save standards like Section 370. 370 is both.
Well, to make insurance companies, using your term now, liable, responsible for payment when they cause the damages and injuries, not when someone else does that, even if it's the renter.
Well, there's no limit in the savings clause that says that the required minimum coverage can't extend to protect the driver as an insured. And for Section 370 fits under both of the prongs of the savings clause. It's both an insurance standard that's tied to the privilege of registering and operating a motor vehicle. That's clear from Section 375.
Let me ask you this. What happened? Let's say we disagree with you. Okay, we don't read it that way. Well, what happens the next day when it comes to someone who is a renter and there's an injury not caused by the rental company, but by the renter or a third party? How are they protected? Because obviously New York State is very concerned about some type of reimbursement for those who are injured in these rental cars.
I think that's a difficult question. The statutory scheme would probably have to be reworked a little bit. It might fall to some of the other backup insurance coverage, such as there's uninsured motorist coverage that might kick in, or the MVAIC has potential coverage, but this would destabilize the insurance market in New York.
I assume that because I think this was your argument before, that your argument would be, well, along these lines, there's some statutory retooling, or some amendment, whatever, to address primary coverage, but because they've agreed that they're liable for or responsible for secondary coverage, whatever might be the overflow, they're going to pay.
That's
that right?
the argument, but I really failed to see how that distinction holds up, because if if it's the case that anytime anytime an insurance company is paying, whether it's primary or secondary, then that's vicarious liability. It's difficult to see how that survives under the statute, which is why we think that argument's wrong. And I do want to note that if there's any doubt about whether
You
there's
both may be wrong about the point, but okay, I
I
understand.
do also want to know that if there's any doubt about whether this is vicarious liability or not, the McCarran-Ferguson Act plainly precludes reading Section 370 as being preempted here. 2 of the 3 prongs are undisputed by the parties. This is, and the Graves Amendment doesn't specifically relate to insurance. Subsection A doesn't mention insurance. In fact, Congress disclaimed an intent to regulate insurance in subsection B. Section 370 plainly regulates the business of insurance. It's a law that sets the terms of insurance contracts. That's in the heartland of laws that are protected by the McCarran-Ferguson Act. And the only reason that the appellate division's distinction was that Section 370 is not entirely superseded by the Graves Amendment, but that's not a requirement under the Supreme Court's case law.
I'd like
or
to
under the
ask you
statute.
about the language, the privilege of registering and operating a motor vehicle, and ask you what the work is that those words are doing. And I'd like you to consider in Connecticut, their trial court said the privilege of registering and operating a motor vehicle under state law is a consideration apart from issues of liability for accidents involving those motor vehicles when operated by lessees. Car rental companies would have to register their vehicles, and employees on occasion would have to operate them as agents. But what does this have to do with the operation of such a vehicle by a lessee? And I think that's a fair question. What does it have to do with it? Why can't it be separate? And why can't the Savings Clause speak directly to the negligence of the car rental company? Why are we making that bridge?
Well, the negligence of the car rental company is mentioned in subsection A. They expressly carved that out from the Graves Amendment's preemptive scope. They didn't do so in subsection B, even though they could have. And it's common for financial responsibility laws and insurance standards to require permissive drivers to be covered. So there's nothing from the text of the Graves Amendment that would suggest Congress wanted to carve that out. And just to return.
There's nothing suggesting that they were adopting your view that it was only about minimum liability either.
Well, the legislative history is replete with references to vicarious liability, that those are the kind of statutes that they were trying to get at. Vicarious liability that imposes limitless liability without fault. But that's simply not the liability that's simply not being imposed under Section 370. It's what was imposed under 388. This is, respondents argue that Section 370 is trying to is a backdoor somehow to imposing vicarious liability. But it's not the case that the state enacted 370 after Section 388 was preempted. Both of these statutes were on the books at the time that the Graves Amendment was enacted, and they served different functions.
Is there any other impact on the rental company and or their insurance company if indeed this is vicarious liability, if we saw it that way, other than this particular primary insurance coverage? Is there something else that flows from identifying it as essentially vicarious liability?
Well, the judgment of they could be held liable in negligence in the first instance, which is a distinction. Otherwise, the accident victim has to obtain a judgment against the tortfeasor driver and the insurance coverage would be litigated afterward. That's one distinction. And there's other legal distinctions, like I said, about when the duty arises and also the potential exposure that the rental company has.
Thank you.
Thank you.
Good morning. May it please the court. My name is Eric Mercurio from Maziakos Mercurio and Associates for respondents Edge Auto Inc. and Maya Assurance Company. The Graves Amendment
Could you address this? I'm over here. Sure. This issue as I think I understood your argument in your briefs that you're not, you and your insurance company are not liable as primary insurers, but you might be liable after excess, and why that isn't just the same as if you're willing to concede that under the statutory framework, the Graves Act does allow for some measure of liability. So why aren't they right?
Sure. So that argument was made in response to the appellant's argument that there could be circumstances where there would be injured people with no recourse, with no insurance. And my argument in response to that is that there is no circumstance in which someone is injured on the road in the state of New York and that they would have no coverage. There's, as counsel noted, there's other statutory schemes with no fault and uninsured motorists and other compulsory insurances. And you have an insured vehicle on the road. You know, subject to a coverage analysis, whether or not that would apply, as counsel said, you know, coverage could be litigated afterwards. But my point in making that argument was that there's no uninsured vehicles on the road. No one is arguing that rental car companies or lease companies.
I think
can
Judge Rivera
allow
is trying to
states-
ask you something a little different, which is, how do you square your view on preemption by the Graves Amendment with your argument that you would still be secondarily liable?
I'm not arguing that it would necessarily be secondary, and that
So is that
it
preempted as well?
to the extent that it would be vicarious liability. Yes,
Well, I don't understand that answer. Is it all vicarious liability?
yes. If a rental car company,
So sorry, so your view then is the Graves Amendment frees you from the obligation to take out any insurance other than for your own direct negligence?
correct.
Okay.
And I take it you do not require renters to show proof of their own insurance, is that right?
Some rental companies can. There's contract.
Do all rental companies require renters to show proof of insurance?
I'm not aware of whether they all require it. I know certain companies do require it in their rental contracts.
And
it
don't
sounds
some
like you may have-
companies offer to extend insurance?
Yes.
Yes, if they pay, obviously, if
Yes,
the renter
the customer
pays.
can purchase insurance through the rental company.
But if there's not a requirement, then it sounds like there may well be, under your reading of Graves, there may well be renters who are driving cars without any insurance to cover that.
No, I don't believe that's
Okay.
accurate.
Well, tell me why that is, because if we don't know that all rental companies require a renter to show proof of insurance, and for example, I have car insurance for my vehicle. I don't
Right.
know if that covers whatever I would drive if I would drive a rental vehicle, but let's assume that it would. If you're not requiring some display of proof, then why wouldn't there be some drivers who are driving rented cars without insurance?
I do believe that most rental companies in their contracts do require their drivers to have insurance. I know in this particular
It sounds like
case,
we can't rule the possibility out, though, that
Most
that
rental
happens.
companies require that the people who rent their cars have their own insurance.
or purchase the insurance through them at the time of rental.
Can I ask you a different question? Are you making an express preemption argument or a conflict preemption argument, or both?
Both. Well,
And so
it is
if you're making both, if we were to read the savings clause as the plaintiffs would have it, as encompassing 370, can you still bring a conflict preemption claim, or does the text then preclude any conflict preemption claim? What's the interplay between the two?
the appellant's position, if adopted, would be preempted to the extent that they are saying that 370 it requires primary insurance coverage, and that it would result in, as the first department concluded, it would result in the functional equivalent of vicarious
I'm just
liability.
asking, I think, a different question, which is about whether or not, as a broad matter, not tied to 370, but as a matter of preemption doctrine, can conflict preemption still proceed if you look at the text and you say that the text not only doesn't expressly preempt, but it's within the scope of the savings clause? Does that control? I mean, the reason I ask is it seems to me conflict preemption is about asking what the legislature intended, right? As is express preemption. And so if the text is clear enough that something's within a savings clause, then it seems to me that the conflict preemption argument would fall away.
Sure. I'm not certain that the text is.
I know you have a view that the text that the savings clause does not encompass 370, obviously, but I'm just asking if one took a different
370,
view.
It encompasses 370 to we are not arguing that the Graves Amendment completely preempts 370, and that because we do understand that the rental companies still must obtain insurance. 370 is not preempted to the extent that it says that now rental companies no longer have to have any insurance.
Insurance for what specifically do you think
For any
survives?
liability that survives Graves as the.
But you are saying that it doesn't require them to provide coverage for their permissive users, the rental company's permissive users.
No, not the renters.
Okay, so let's go back to this response you just gave for they're liable for anything that survives Graves, so let's talk about that. So your view is what doesn't survive Graves is primary insurance coverage for the renter.
The negligence.
Okay, when your company, when the rental company has no negligence, like they're not the cause of the damages or the
Correct.
injuries, correct? Okay, so where does this secondary insurance responsibility come in? When would that kick in, if at all?
Like I said, it was in response to the argument that there would be no insurance, and I'm arguing that there are other avenues, and subject to a coverage analysis, it may or may not apply on a secondary basis. That's every case to be determined on its.
But what would be the basis for the secondary insurance? If your view is that Congress didn't intend for the rental companies to pay for the liability, the actions, the negligence of renters or perhaps third parties.
It would not, Your Honor. It would not be a secondary.
So then again, back to your response to Chief Judge Wilson, that this, despite whatever language might be in your brief, your position is you're only liable for your own negligence. That's it, and that's what Graves intended, the Graves Act amendment intended.
So if a rental company, under your view then, of what the Graves Amendment does, a rental company rented to somebody who had no insurance themselves, is that negligent?
Well, if they provided proof, let's say they provided a certificate of insurance that.
No, suppose they don't ask. They don't ask. They rent me a car without asking if I have insurance.
I find that scenario to be unlikely that they would allow a car on.
I have to tell you, I rent a lot of cars. I've never been asked to prove that I have insurance. Never.
Okay.
Now, you do have contracts that someone who rents some insurance, some rental companies that indicates, yes, I have coverage.
Yes. Okay. In this instance, the rental agreement in this case with Edge Auto, they do require their renters.
Is that part of what you mean in terms of the different ways that rental companies handle this particular situation?
Yes.
But do you agree that there are rental companies who will rent to someone who either doesn't represent they have insurance or cannot prove they have insurance or has refused insurance coverage?
I cannot speak for every rental company.
Okay.
I don't.
Do you
That's
think
fine.
there's some sort of difference of practice at various levels of the industry? Because I think Chief Judge Wilson is right. For most of us who go to these big national car rental companies when we're traveling domestically or overseas, no one asks us to provide proof of insurance when we rent a car. Maybe you have to be older than 25, which I've been able to do for a while, and have a credit card, which I've also been able to do for a while. But I agree, I've never been asked to prove that I have insurance. And I've done it. I've rented cars at a time when I didn't own my own car and didn't have a driver's policy. So are we possibly talking about there's a difference between the way the national companies do it and more regional and local companies do it?
Sure. I mean, I can speak for, like I said, my client in this case is Edge Auto. Edge Auto is a rental company that specializes in commercial rentals with their clients and customers typically are television and movie video production companies. They rent commercial vehicles. Those contracts are negotiated at arm's length, usually with other attorneys, and their contracts require.
But this statute is going to apply to the whole industry, right?
Right.
Including some rental companies who I think there's a strong suspicion, at least among some members of this court, do not really inquire or take into account whether or not the person renting a vehicle from them has their own insurance. And as an addendum to that comment, if you want to address it, I think the end result is that you're definitely going to have more people shunted into the uninsured motorist coverage part of this scheme.
Yes, I understand that. What was the question?
The question is, I mean, is that a natural consequence of your position?
Yes, it could be, yes.
Let me ask you this, since the Attorney General's representative already discussed potential statutory tweaking, or that the legislature could perhaps consider that, could the legislature, unless it already does, I don't know, you may know, does the legislature, could it require that all rental companies have the renter provide proof of insurance coverage?
Sure.
And if they don't provide such proof, they may not rent to them?
Could the legislature enact?
Yes, I'm asking you
Yes.
that.
I don't see any reason why they would not be able to enact such a law.
What do you think the purpose of the savings provision is?
The purpose of the savings provision is to save laws like 370 that say for the privilege of putting a vehicle on the road in your state. So for anyone to put a vehicle on the road in the state of New York, it has to have minimum levels of insurance.
But what does that mean operationally? I think you're telling us it doesn't mean that 370 survives, right? So how does that actually?
Well, 370 survives to the extent that, yes, if a rental or leasing company has to have the minimum levels of insurance to put a car on, to register the vehicle for any type of liability that survives Graves, as the first department held. So for any of the negligence of its agents or employees, or for its own active negligence or criminal wrongdoing
But
in connection with its vehicles.
okay, but that type of insurance, as I understand it, tell me if I'm getting this wrong though, has to do with the direct negligence of the car rental company. I don't know what that might encompass. Perhaps it would encompass, failure to service a vehicle, you send a car out with flat tires, something like that. But around the mechanics of the car itself. I take it you're saying, though, that it doesn't encompass any provision of insurance that would cover an injury in the course of the renter driving the car,
As that would violate the Graves Amendment, yes.
as you read it, right?
Yes.
So are you saying there are other types of insurance? Because the way I understand it, there are 4 types of insurance, right, for motorists in New York. There's liability, there's property, there's underfunded insurance, and I forget what no fault.
No fault.
Right. So is your position that the savings clause only goes to the liability part, and that the rental car company would still be liable to register and insure their cars for these other insurance?
Whatever they're required to obtain insurance for pursuant to the statute, they still have to obtain that insurance. Where our position is that insurance cannot be primary to cover the negligence of the driver.
But how is the type of insurance for direct negligence, so flat tire, whatever it is, how is that something for the privilege of registering and operating a motor vehicle? When I look at those words, I think about it as a car owner, right? In order for me to register and operate my car, I need the same no-fault insurance that everybody needs, right? Why isn't that the most natural reading of this provision, as opposed to the reading I think you're asking us to give it, which is insurance that covers only direct negligence?
We're not arguing that they don't have to obtain those other insurances.
Well, I thought the crux of your argument was that your client doesn't have to bear the cost of obtaining insurance for liability occasioned by an accident on the road.
Right, liability insurance for the negligence of
And
the
why
driver's
isn't liability
uninsured motor-
insurance?
I'm sorry.
It's okay. Why isn't liability insurance the type of insurance that we obtain for the privilege of registering and operating a motor vehicle, which is what the savings clause covers?
Because that is expressly preempted by the Graves Amendment. Liability insurance is...
Well, I'm reading to you from the savings clause. So the scope of the Graves Amendment is constrained by the savings clause, right?
So the only insurance that is impacted by the Graves Amendment is the liability insurance.
Why not the no fault?
The Graves Amendment doesn't impact the obligation to obtain no-fault insurance or
Why,
uninsured motor
but
or
why
other-
not?
Because it's not it's not vicarious liability. Uninsured motorist is not coverage that
It's
is
liability. I mean, your client wasn't driving the car that caused the crash, even if it's covered by no fault.
right.
So the liability arising from the crash that is covered by no fault is responsibility of the driver or drivers. We don't know which between them because we don't care under our statute.
But it's not vicarious liability for the negligence of the driver and
Why not?
third-party liability.
I mean, it's a third party whose
Uninsured
negligence
motorist-
caused it,
an uninsured
not
motorist
yours.
claim is irrespective of liability. In fact, it's because the liable tortfeasor did not have adequate coverage. That's why you purchase that insurance as protection. It's compulsory insurance to cover that exact instance. It's not a vicarious liability that is impacted by grace.
But if you
That
have
is not
to, if
the-
you
the
have to
type of
buy that insurance policy, you were paying for something that wasn't caused by you, which I thought was how you read the Graves Amendment.
Graves Amendment is to prevent the third-party liability for the negligence of the driver. The uninsured motorist claim is not about the negligence of the driver. You're not being vicariously liable for your own driver. It's because of the circumstance of getting into your vehicle is in an accident with an uninsured tortfeasor. That's why you purchased that insurance. That is not what Graves Amendment sought to preclude.
Is it primary? Is no fault primary?
No fault is primary.
Is primary.
Yes, typically, yes. For that instance, it's for that reason why Congress enacted no fault, is to make sure that everyone who's involved at least has that level of coverage. That is not the coverage that the Graves Amendment sought to preclude.
Do you want to address the McCarran-Ferguson Act?
Sure. The Graves Amendment does not impact or impair 370 to the extent that it says that 370 says you have to obtain this insurance, and now the Graves Amendment is saying you don't. These rental companies still have to have the insurance. We're not claiming that they don't have to have insurance. We're not claiming that rental companies ought to be allowed to roll cars out onto the streets of New York with no insurance. That's not what we're arguing. 370 is alive and well post-Graves to the extent that it requires the companies to obtain insurance. We're not arguing that they don't have to have
Well,
any
certain
insurance.
kind of insurance, you're saying, a very specific kind, not the kind that covers what actually happens on the road due to drivers, right?
Due to the negligence of the driver, because that was the only circumstance that was expressly preempted by the Graves Amendment. Graves Amendment did not preempt the other forms of insurance.
We're just saying it would not be unlawful for a rental company to rent to someone who has no insurance coverage. At least not as of now.
Correct. Okay. Do you have any other questions?
Don't think we do.
Okay, thank you.
Thank you.
Your Honor, you posed a great example. You yourself are a car owner. I'm assuming you have insurance that was written in the state of New York. I'm by no means saying that you would ever do this, but suppose you let somebody use your vehicle who did not have car insurance. You can be held liable for their negligence, but thankfully you have insurance that's written in the state of New York, and under New York insurance law 3420, your insurance company is required to insure the permissive user of your vehicle. That's the same principle that applies in vehicle and traffic
Congress
law
didn't
370.
preempt that law, right?
No.
So I'm having still a little difficulty on the McCarran point. Could you go back to that?
Sure. So McCarran states that no act of Congress shall invalidate, impair, or supersede any state law that has been enacted to regulate the business of insurance.
And your point is this impairs, right?
Absolutely impairs, because it impairs, invalidates, or supersedes the peremptory mandate of Vehicle and Traffic Law 370 that states that those minimums shall inure to the benefit of every permissive user. And then it continues to the same extent and to the same manner as the owner. If the owner is negligent, the insurance is going to respond. Likewise, if the renter is negligent, the insurance is going to respond up to those minimums, 25, 50, 10. And it's not limitless because if there's more, the rental company can seek indemnification from the renter. That was the holding of Morris. That was also in Ward.
Impair and McCarran-Ferguson as just taking a little bite out of as opposed to completely invalidating it? How broadly do you think it's
Well,
swept?
the lower court erred because they read the word entirely into the statute. They forgot the maxim that the court should give effect to every single word and clause of
But is the case law interpreting McCarran-Ferguson clear in your view that impair includes take a little bite out of? So, for example, if part but not all of 370 would be preempted under your adversary's reading, is that sufficient to trigger McCarran-Ferguson?
Correct. It only has to impair, invalidate, or supersede part of the state statute in order to trigger an act, and that in turn triggers reverse preemption.
Different point. Could an insurance company, as part of the contract, rental contract, say to the potential renter, you have to buy a policy from me, rental company, that covers me for my liability under 370. So you're not liable, because we don't use that word, but you have to have insurance to cover my non-liability for my insurance coverage.
Well, that's exactly what 370 says. It says that you have to have those minimum
But can
amounts and
the
those minimum
car company make the renter buy that from the car company? So the renter then buys a policy covering the rental car company for the obligation under 370.
Well, no, because the rental company would still be primary. And again, that was the holding of Morris. That was the holding of LRAC v. Ward, where they could seek to do that, but it has to be for amounts above the minimum. Not
So
within.
there's no way, and there are a lot of questions about you could have them buy a policy, you could have them, there's no way the rental car company can shift that risk to the renter.
Well,
under
no, because then they're effectively trying to shift the statutory obligations that they have under vehicle
that's
traffic
the
law 370.
different policy than requiring somebody to have insurance on the road, because that essentially would accomplish the same thing as 370. It's just making sure the rental company pays.
Not making sure the rental company pays. This is making sure that there's critical insurance benefits for for innocent victims
And that
of
the rental
traffic accidents.
company pays for those benefits.
Up to the minimum. There's not
Right.
limitless payment, and it's not the rental company unless the rental company is self-insured. It's the insurance company
Which
behind.
I know some of the bigger ones do, I guess. But the point being, I think that there's no way the rental car company could accomplish the same consumer protection or driver safety, whatever you want to call it, coverage by passing those costs along. This statute mandates that the rental company bear this financial responsibility.
Primary coverage mandated. The exact words of the statute state shall, and that is what the court determined in LRAC v.
And for
Ward was that it's
purposes
primary.
of McCarran, would that be an impairment as well of an insurance regulation? In other words, if a car rental company just decided we're going to build this into our rental cost, we're going to have the consumer pay for the coverage. And mind you, that's not vicarious liability as I understand you've defined it. That's just shifting a financial obligation to the customer. Does that run afoul of reverse preemption?
Well, no, insurance companies are free to hike up their prices in order to cover their premiums, as well as insurance companies to cover themselves if they have to start insuring renters for every single rental company up to those minimum limits. But that's not the case because so far what we've relied upon was that the rental companies would come in at the minimum and then the renter's insurance could kick in for amounts above that or a third party who was at fault. And that's been the law of the land since 2001.
Well, that's better for the industry because I think the whole genesis of this is that the car rental companies were claiming that their costs were so high that they were being essentially driven out of business. So I guess the question then becomes, whose goal are we serving if you build it into the cost? You're not helping the rental companies. You're not getting to what the original legislative intent was, which was, I think, to sort of reduce these onerous obligations on the rental companies. Would that be fair to say?
Well, they would not have those onerous obligations because they would only be held to those minimum limits. And so
Onerous is in the eye of the beholder.
Well, on the flip of that, it would be onerous if, let's say, you had someone who was operating a rental truck with no insurance and now an innocent victim who was trying to seek financial recourse, but then you had a renter with no insurance and a rental agency saying, no, we don't have to provide.
Well, I
primary
think we've
coverage,
already
we're not
established
liable on
that
your grave, so we're not going to pay anything.
I mean, that seems, that's a vivid image, but there's still forms of coverage available out there, right? There's still underinsured, uninsured motorist coverage that's available.
Well,
And the car rental companies are paying for that even when they buy their own policies for their own negligence.
no fault insurance by its very nature is providing this insurance without having to prove negligence. So in essence, it's vicarious liability. And now that gives rental companies the opportunity to say, wait a minute, this is vicarious liability in a sense. So we don't have to provide no fault. We don't have to provide underinsured or uninsured.
Well, that's really the next case, though, isn't it?
Exactly. That has not been briefed
that-
before
that
this
has
court,
nothing
but
to do with
that could be the
Graves.
likely effect of it.
That has nothing to do with Graves, because Graves is only talking about liability, right?
Well, exactly. So Graves is talking about liability, and that's VTL 388. We're talking about compulsory insurance coverage under 370.
And the
that
words
works in tandem with
primary, like the
3420.
primary policy, did that come from 370 or did that come from our interpretation of Ward?
Well, Ward took that from the language of the statute that says shall in order to the benefit of every
No, but I'm
permissive user.
asking about the words primary, like when we're talking about it in that regard. Is that based on our interpretation through Ward or is that based on 370?
That does not appear in 370. That came from the Ward
Right, so
decision.
now is our interpretation of Ward still good law after Graves?
Absolutely. It's still good law
How?
because there's no vicarious liability. It's compulsory insurance coverage up to a minimum
I don't
limit.
understand what that means, because the insurance coverage is for the benefit of somebody getting paid, right? Practically, that's what we're talking about.
Yes, to make sure that there's
And the
access to
Graves
critical
Amendment
insurance
says
benefits.
the rental company shouldn't be the one paying.
Well, what Graves said was that they should not be vicariously liable for these incidents. It did not say we're going to restrict insurance. You cannot get insurance. It just covered vicarious liability, not insurance principles. That was
You're
left to the
saying if
state to
there's
regulate.
any liability, the rental car companies shouldn't bear that responsibility.
Well,
Clear as day.
again, they're not bearing liability. What they're bearing is insurance coverage. So the renter, as a
Again,
permissive
but the
user,
insurance coverage is for the purpose of funding someone, making someone whole. That's the purpose, right?
yes, it's to make someone whole. But again, the rental company is, and they're insured, they're obligated under 3420 to insure the permissive user of a vehicle. So if we're going to preempt the peremptory mandate of Vehicle and Traffic Law 370, we're also going to preempt 3420 that says that every single insurance policy written in the state has to insure permissive users of vehicles.
No, I don't think that necessarily follows, but I appreciate your argument.
Thank you.
Thank you.